Family Maintenance and Support (FMS). Can you challenge a will in Alberta? Let's say someone close to you passes away and leaves behind a will, but you or someone else was left out, and it doesn't feel fair. In Alberta, the law allows certain individuals to challenge a will under what's called a family maintenance and support claim, often shortened to FMS. An FMS claim allows specific people like spouse, adult interdependent partner, minor children, or dependent adults to ask the court for a fair share of the estate, even if the will says otherwise. The court evaluates whether the deceased had a moral or legal obligation to provide support. The court doesn't automatically change a will, but if someone can prove they were financially dependent or unjustifiably excluded, the judge can order a redistribution of the estate to provide that support. Why it matters? This process protects vulnerable family members, especially in cases where someone was financially relying on the deceased. It's also a safeguard against outdated wills that do not reflect current relationships, like common law partners or estranged children. But keep in mind, there are strict timelines and legal hurdles to cross.
Common questions about family maintenance and support. Who can file an FMS claim?
Spouses, adult interdependent partners, minor children, and dependent adult children, if they relied on the deceased for support.
Is there a deadline?
Yes, you must apply within 6 months of the grant of probate.
Does this delay distribution of the estate?
It can. Executors are advised to hold off a distribution until the FMS period passes or the claim is resolved.